School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Block 3 Business Contracts, Unit 6 International Contracts of Sale, Part 2.
Model contracts and clauses. International contracts refer to a legally binding agreement between parties based on different countries in which they are obligated to do or not to do certain things. International contracts may be written in a formal way. Most businesses create contracts in writing to make the terms of agreement clear, often seeking legal counsel when drafting important contracts. Contracts can cover all aspects of international trade, although the most commonly used are: Number 1. International sale contract. Number 2. International distribution contract. Number 3. International agency contract. Number 4. International sales representative contract. Number 5. International supply contract. Number 6. International manufacturing contract. Number 7. International service contract. Number 8. International strategic alliance contract. Number 9. International joint contract. And number 10. International franchise contract. Model contracts are particularly useful for preparing international business transactions, but they are often expensive. The International Trade Center offers for free online its model contracts for small firms and legal guidance for doing international business. The ICC offers for purchase an array of model contracts for international transactions, including an influential model for sales contracts. The contracts are the products of some of the finest legal minds in the field of international commercial law. They are constructed to protect the interests of all the parties, combining a single framework of rules with flexible provisions, allowing the parties to insert their own requirements. Arbitration institutions and rules typically offer model clauses that can be useful for incorporating an arbitration clause in a contract. For example, the model clauses of the Arbitration Institute of the Stockholm Chamber of Commerce, the LCIA, and the International Center for Dispute Resolution. Choice of law clauses can be found in the model contracts mentioned so far, but there are also other sources. UNIDROIT, for example, has prepared model clauses for the use of the UNIDROIT Principles of International Commercial Contracts. Some arbitration institutions also offer model choice of law clauses. For example, the clauses from the Chinese European Arbitration Center. The ICC Confidentiality Agreement is the latest in a series of widely used model contracts published by the International Chamber of Commerce. The ICC Force Majeure Clause 2003 and the ICC Hardship Clause 2003 are the examples of the model ready-made clauses to be inserted by the parties in their international commercial contract. Assessment of sale of goods by transfer of property with certainty and flexibility. The transfer of property takes place when the contract is concluded, even the delivery and payment of price happens subsequently. This principle was adopted by French law by Code Civil of 1804. The same appears in English rules set out in Sale of Goods Act, that is SOGA 1893. The other system of transfer of property is stipulated by the delivery, which was seen in German law and Australian law. The former talks of abstract delivery and the latter with casual delivery. The transfer of property, that is, the ownership, belongs to the realm of general formulas, while the solutions of the various practical problems belong to the realm of operational rules. Thus, it is observed that even legal systems with contrasting general formulas can share identical operational rules. When questions emerge from the perspective of the ownership, the judge must refer to the domestic law applicable according to the usual rules of conflict. The absence of precise rule in the CISG is not a loophole. It was a deliberate choice by the drafters to leave it to the judge to decide, as it was a highly sensitive aspect in the sale of goods. This facilitated the adoption of CISG by divergent legal systems that adopt one solution or the other for domestic sales. A certain degree of certainty is attributed to the sale laws that guarantee the maximum predictability of the solutions asked by the judges and arbitrators. This implies that legal rule must be as precise as possible and must avoid loopholes, generic directive for the parties, or interpretation gaps for the decision of cases. On the other hand, any sale law that contains general clauses such as the good faith principle, binding the contracting parties to behavior whose legitimacy is decided after the event by judge or arbitrator, is considered flexible. In particular, the English law considered a bulwark of certainty and German law is considered as very flexible. The former does not have an obligation to act in good faith, while in latter, good faith and reasonableness permeate the entire spectrum of contract relationships. The tension between certainty and fairness is solved by the CISG principles. CISG influence on individual national systems. It was noted by the scholars that CISG is having an impact regarding both sales of goods, obligations law, and contractual law generally on the numerous legal systems. Its influence on individual legal systems may be felt by the courts, by doctrine, by legal practice, and lawmakers. The Dutch judges used the CISG principles in interpreting the national law regarding the formation of contract, breach of contract, and non-conformity of goods sold. The Scandinavian countries, except Denmark, revised their National Sale of Goods Acts in line with the most of the principles of CISG, Finland in 1988, Norway in 1989, Sweden in 1991, and Iceland in 2000. The CISG influenced the Europe by the Law of Obligations Act in 2002, which is the identical transposed bindings nature of usages and practices, the objective interpretation of the declaration of intent, the freedom of form, the mitigation of harm, and the prohibition of abuse of rights. The Tokelau Islands has adopted the rules of the CISG as domestic law, both for the sale of goods and for general contract law. In the largest economy, China, the CISG has essentially become a part of domestic law. The Contract Law 1999 was amply supported by CISG rules. The drafters of new Chinese Civil Code were able to find in the CISG a very important resource of rules, both for the sale of goods and the contract law in general. In some legal systems, reforms in the national laws have begun or have been suggested. New Zealand's Sale of Goods Act 1908 is the example of this reform. The largest economy in Africa, Nigeria, though not ratified the CISG, Nigerian Law Reform Commission began to consider a reform of the Sale of Goods Act 1893. It reproduces the Old English law on sale of goods And now there is a call for the reform to take the CISG as model law. Japan didn't ratify the CISG for a long period. The scholars noted that CISG rules are arguably better than the Japanese sales law. The ongoing reform of the Japanese law of obligation could raise the level of reception of CISG principles and rules in the Japanese legal system. The Turkey New Code of Obligations deeply reformed the contract law, which was based on the Swiss model adopted in 1920. 17 Central African countries who are currently the members of the Organization for the Harmonization of Business Law in Africa, that is OHADA, intended to remedy the legal and juridical uncertainty that exists among the signatory states. In 1997, they adopted a uniform law governing commercial law, which was modified and modernized in 2010. This regulates all the sales of goods between companies and excludes the sales to customers. With French culture, they adopted the CISG principles to domestic sale of goods, including several rules deriving from English common law. Regional efforts. The preamble to CISG states that the adaptation of uniform rules which govern contracts for the international sale of goods and take into account the different social, economic, and legal systems would contribute to the removal of legal barriers in international trade and promote the development of international trade. The European Commission proposed a new uniform law on the sale of goods, intending to solve the problems arising from this diversity of national contract laws. The Common European Sales Law, that is CESL, governs sales to both consumers and businesses. The CESL would then offer a new choice between the legal systems that the parties can make freely, any national law either of EU members or of other states. The Association of Southeast Asian Nations, that is ASEAN, approved the ASEAN Trade in Goods Agreement. These treaties expand the free trade area beyond the borders of the community of ASEAN countries and envisage the gradual implementation of the free circulation of goods between ratifying states, elimination of customs and protection barriers. However, these treaties do not contain rules to be applied to the international trade contracts but are limited to encouraging strong regional standardization. The UN CITRAL and The Hague have recently established regional centers that offer a significant opportunity to promote the various private international law instruments, including those relating to international contract law. In the light of the importance of the issue, efforts by the UN CITRAL Secretariat are welcome to explore other means of promoting and maintaining uniformity in the interpretation of the CISG. The Secretariat recently proposed the establishment of a system of national centers of expertise in the field of commercial law that go beyond the current national correspondence system of case law on UN CITRAL texts, that is, CLOUT. According to the Secretariat, the system would: number 1. Collect, analyze and monitor national case law related to UN CITRAL texts. Number 2. Report the findings to UN CITRAL. And number 3. Address the need of the judiciary to better understand the internationally prevailing application and interpretation of UN CITRAL standards and achieve effective cross-border cooperation. Resources are the biggest obstacle to such a proposal, as noted by the Secretariat. Cooperation. The UN CITRAL and its sibling operations, UNIDROIT and the Hague Conference, should continue to coordinate and cooperate on all matters regarding the international contract law in order to ensure that the organization's agendas remain complementary. The UNIDROIT and UN-CITRAL have recently supported consideration of joint collaboration between the two organizations on substantive law projects as suggested by the US. These two may consider a joint project on long-term contracts. Naturally evolving harmonization through progressive interpretation and the use of existing instruments will continue to ensure that harmonization is workable and feasible. The CISG and PICC working together have been remarkably successful in addressing the needs of commercial players in international commerce. There are more practical, positive, and forward-looking alternatives that build on the existing platform of the CISG and the PICC. The UN-CITRAL must continue its efforts to assist states in maintaining uniform interpretation and implementation of the CISG. Battle of Forms. Battle of the Forms is one of the unresolved legal problems to which different countries' courts have their own approach. There are three main approaches in the literature as to the Battle of Forms: domestic approach, last shot rule, and knockout rule. The last shot rule and knockout rule are in competition with each other. The courts are required to answer two questions. Number 1. Is there a valid contract between the parties? And number 2. If yes, which terms of the standard forms are the parts of the contract? The CISG has not given uniform answers to solve the arisen disputes. The Battle of Forms dilemma can't be resolved by single formula, as there are different situations of collusion and the various positive behaviors of the parties. The CISG is not concerned with validity of contract. Which standard terms should be incorporated into the contract shall be solved by the applicable domestic law. The courts are required to look to the general principles of the CISG first before recourse to domestic law. Domestic approach is not widespread, as this is inconsistent with the main reason with the existence of CISG, namely unification of the sales law. A reply to an offer which purports to be an acceptance but contains additions, limitations, or other modifications is a rejection of the offer and constitutes a counteroffer. The traditional common law rule, namely the mirror image rule, produces the last shot rule in order to answer the Battle of Forms issue. The last shot rule treats every statement made with reference to confliction standard terms as a rejection of the earlier offer combined with counter-offer. In other words, the contract is concluded on the terms of the final form used without being objected by the other party. The conflicting standard terms knock each other out and the provisions of CISG are applied instead of them. The courts are to find the actual or deemed consensus of the parties based on their negotiations in respect of the essential elements of transaction. The aforesaid analysis of the Battle of the Forms make it clear that knockout rule is supported by scholars and cases because of advantages such as conformity with the intention of the parties to the business, balanced and fair approach, supportive approach to the contract validity issue, and providing uniform application of the convention by referring to its provisions in case of knockout terms. COVID-19 pandemic and its impact on the performance of international sale of goods contract. A force majeure clause in international sale of goods contract relieves a party from performing its contractual obligations when certain circumstances beyond its control arise, making performance inadvisable, commercially impracticable, illegal, or impossible. The CISG Article 79 provides that a party is not liable for a failure to perform any of his obligations if he proves that the failure was due to an impediment beyond his control and that he could not reasonably be expected to have taken impediment into account at the time of conclusion of the contract or to have avoided or overcome it or its consequences. The treatment of impediment under CISG is different from the treatment under common law. Generally, 4 conditions must be satisfied to assert the force majeure protection under the CISG. They are: Number 1. The impediment must be beyond the party's control. Number 2. The impediment is unforeseeable at the time the contract was signed. Number 3. The impediment and its consequences could not be reasonably avoided or overcome. And number 4. The non-performance of the party is the result of the impediment. Under Article 2 of the Uniform Commercial Code, that is UCC of US, a seller may be excused from delay or non-delivery of the goods if performance has been made impractical by either: Number 1. The occurrence of an event, that is, the non-occurrence of the which was a basic assumption on which contract was made, or Number 2. Good faith compliance with foreign or domestic government regulation. The common law doctrines of frustration and impossibility may be invoked, but they have a higher threshold to overcome. Predating the COVID-19 pandemic, well-known examples such as contractual arrangements are found in model clauses issued by International Chamber of Commerce, that is ICC, namely ICC's 2003 Force Majeure Clause and the ICC's Hardship Clause. This has changed with the ICC's 2020 Hardship Clause, which suggests 3 different legal consequences in the event of failed negotiations, any of which the parties can choose when concluding the contract. These 3 consequences are: Number 1. The termination of the contract by one of the parties. Number 2. The termination of the contract by a judge or arbitrator. Or Number 3. The adjustment or termination of the contract by a judge or arbitrator. To combat uncertainties for future crises like COVID-19, it is therefore advisable to negotiate individual contractual clauses pertaining to force majeure and hardship in order to determine the desired distribution of contractual risk in advance. Now let's summarize the unit. In business-to-business international transactions, it would appear that the market is operating effectively and the differences in contract law do not pose a serious obstacle to cross-border trade. The conventions, the national laws, soft laws and trade usages, unit-droit principles, lex mercatoria, Incoterms, UCP 600, model contracts and clauses, CISG, PICC, UN Citral principles will help to overcome the obstacles faced by the parties in their cross-border trade through international contracts of sale of goods.
We were listening to the audiobook by the School of Management Studies, IGNOU, for MBA program. Course code MMPC-013 Business Law. Course Coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.